Hello, how are you?
Good afternoon, ma.
Good afternoon, how are you?
Fine, ma.
Fine, ma'am.
Nice to meet you all.
Same here, ma'am.
Thank you. Hello, how are you?
Okay. Good evening, everyone. You're welcome to the fourth quarter of the JIIPCC Mentorship Program for Intellectual Property. Good evening.
Hello, good evening.
Good evening, Chandra.
Juliana, yeah?
Yeah. My name is Amaka Sanjanweli.
Yeah.
I'm
nice
a
to-
legal practitioner and an intellectual property enthusiast, and I'll be your moderator for today. Big welcome to everyone. Welcome, Nirvana.
Welcome,
Hi,
dear.
Mrs. Juliana.
Hi, nice to meet you.
Nice to see you, Sandra. Nice to see you, Nirvana. Thank you for joining
dear.
us.
Nice to see you all.
Hi,
Thank you.
Hussein. I'm seeing a lot of people. Hi, Annie.
Okay, camera.
Good afternoon, Amaka Sandra.
Welcome, everyone. I'm sure we are ready for a mind-blowing section. Welcome, everyone.
Welcome, dear.
Okay, so quickly, we'll be going straight to the activity for today. But first, let's take a brief overview of what the mentorship program is about. Okay, so the JIIPCC Intellectual Property Mentorship and Internship Program is a quarterly program for students and young professionals across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forum, industry updates, and resource materials from experienced mentors. This program seeks to encourage continuous training, development, and evolution in Africa and around the world. You can watch our videos by searching for JIIPCC on YouTube and Facebook using the hashtag JIIPCCMIP. So you might be asking, what are the objectives of this program? Firstly, to provide easy access to quality professional guidance, training, and resource materials for students and young professionals in Africa. Secondly, to facilitate dialogue and network among less experienced practitioners and stakeholders. Thirdly, to transform mentees into mentors and leaders for the next generation. And finally, to facilitate further mentorship, internship, scholarship, and job placement for the mentees. So this is like a brief overview of what the program is about. So I'm sure that our mentors, rather our mentees, are ready to draw from this wealth of knowledge and a very, very rare opportunity. So I enjoin everybody to sit tight and enjoy the rest of the discussion or the rest of the meeting. So before we start, let's do like a quick announcement and housekeeping.
Sorry, Amaka Sandra is muted. I don't know if you can hear her. Can we all hear her?
No, I can't hear her.
Okay, so I'll continue from where she stopped. So the announcements for today is the first quarter of JIIPCC mentorship program for next year is currently ongoing. And the courses we have are intellectual property, artificial intelligence and technology, the energy industry, fintech, health tech, and law and patent drafting. Please feel free to share these courses with your colleagues and friends if they're interested in the next quarter, which is the first quarter of 2023. Thank you very much. Our next announcement is that we'll be having a 30-minute one-on-one mentorship with your favorite JIIPCC mentor. This is a program organized for those that are interested in having a private session with any of your favorite mentor. You can register through the link bit.ly/JIIPCCPM. So another announcement for today is that we'll be having a get-together picnic for all JIIPCC past mentees in Abuja and Lagos on the 10th of December 2022 in Abuja and on the 17th of December 2022 in Lagos. All our mentees are advised to attend the JIIPCC get-together party because it will be fun and very lively. Thank you very much. So I think Amaka is back with us, so I will hand over the moderating to her now. You can unmute yourself, Amaka.
Okay, sorry for that, everyone. So I'm glad Hussein was able to take over. Sorry for that. There was a hitch in my network. So we'll be going straight to our mentors. We'll be looking at our mentors profile. We have great mentors in our midst today. So before the presentation starts, it would be a good thing to look at the profile of our mentors so that we can appreciate the wealth of knowledge that we are about to drink from. So top on our list is Nirvana Chalk. I'm sorry if I didn't get that correctly. She is an entrepreneurial intellectual property rights and affairs executive, offering 26 years plus of law firm and in-house corporate experience combined. Instrumental in mitigating risks, building organizational capacity, driving optimization, and securing multi-dollar deals. Experience in partnering closely with C-level executives on a wide range of legal compliance, operational, finance, employment, and strategic business matters. Expertise in licensing, acquiring and enforcing intellectual property rights related to platform. Leverage business acumen and legal expertise to growth while resolving complex issues within high energy and fast-paced environments. Represented clients in commercial litigation, transactional and intellectual property matters across a wide range of industries in the Gulf nations. You're welcome, ma'am. Thank you for joining us, Nirvana.
Thank you, dear. Nice to meet you all. I'm so glad to share today with you my presentation and answer questions of students for JIIPCC and hope to repeat it, inshallah.
Thank you. Thank you so much, ma'am.
Thank you.
Okay, so second on our list is Uche Nwokocha. Uche Nwokocha is a Harvard alumni. She is in the firm of Aluko and Oyebode. She joined the firm in 2003 and was admitted to partnership in 2008. She has experience in trademark, clearance and exploitation, patents, dispute resolution, franchising, technology transfer, product registration with NAFDAC. After graduation from law school, Nwokocha gained Masters in International Law and Diplomacy in 1997 from the University of Lagos. She heads the intellectual property department of the firm and advises local and international clients on full range of brand-related matters, including licensing and franchising of technology transfer agreements with NOTAB. Uche was selected an outstanding intellectual property practitioner in the Elite World IP Review Leaders 2022. She was featured by Legal Business Africa as one of the 20 outstanding Nigerian women in business law. for 2021. Recognized as a leading patent and trademark practitioner in the World IP Review Leaders 2021 Guide, and listed among the 11 individuals ranking across 5 main practice areas that are researched and evaluated by Chambers Global for Nigeria for 2021. She was ranked among the 2020 World Trademark Review 1000, recognized in Who's Who Legal in 2014 and 2020 as a global expert in intellectual property. Top 250 women in IP for 2020 by Managing Intellectual Property, MIP, which also named her an IP star 2016 to 2021 and 2019 by the World IP Review. She served as a board member of the INTA from 2018 to 2020 and was assigned to the Finance Committee for 2020 and was nominated by the US Mission in Nigeria as a panelist to celebrate World Anti-Counterfeiting Day 2021.
Thank you so much.
Uche currently serves as a board member at the Global Anti-Counterfeiting Group and Secretary of Anti-Counterfeiting Collaboration. Thank you so much, Ma, for joining us. We're glad to have you.
The honor is mine. Thank you.
Thank you so much, Ma, for joining us. It's so good to see you again.
Likewise.
Thank you, Ma.
The next on our list is Mr. Max Ikombe. Mr. Max Ikombe is the founder and principal of Ever Law Associates. He works extensively in the fields of arbitration, ICT and technology law, and intellectual property. Max is a facilitator on the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy, and he is an accredited agent of the Nigerian Trademark and Patent Registry and has conducted IP registration businesses there since 2010. Thank you so much, sir, for joining us. Okay, so we'll be going on to the presentation. Our mentees are reminded that they have 8 minutes for their presentation. Our topic for today is IP for businesses. So if the representative of Group 1 is ready, the floor is yours for your presentation. Remember, you have 8 minutes for your presentation.
I am, Ma. Good afternoon. Good afternoon, Ma. Good afternoon, everyone.
Good afternoon.
Good afternoon.
Okay. Do I have to put on my radio? My video, please?
Yes, put on your video, please.
Okay. Good afternoon. I don't know if you can see me.
Yes, we can.
We can.
All right. Okay. Good afternoon, everyone. My name is Adidamola Aditsula, and I'm a member of Group 1. I would like to thank the mentors and the organizers of JIIPCC for this privilege. So today I'll be making a presentation on patent and trademark. And I don't know if it's on. The person sharing the screen. Let me dive. Okay, so I'll just proceed. So very quickly, before I start on patent and trademark, I'd like to give a brief introduction on what intellectual property is about. So intellectual property is an intangible asset. So when we say something is intangible, it means that it cannot be touched. It is not physical. And also it refers to their rights that gives to creators, and there are also rights that are given for the creation of minds. And we have several examples of intellectual property, and they could refer to inventions, literary or artistic works, they refer to designs or symbols, And in the next slide, please, can you go to the next slide, Timmy? Yeah, in our next slide, we give examples of IP, and which are trademark, industrial designs, copyrights, trade secrets, patents, and even design rights, amongst others. So, however, beyond having these rights, they need to be protected, because in an instance where they're not protected, then people's right could be infringed upon. And that is why there are different ways in which they could be protected. And we, in our next slide, we explained how the rights could be protected. And the first one we said, please can you move to the next slide, Timmy? So in our next slide, we said that, okay, you need to register your trademark with the trademark registry. You can also obtain patents and industrial design grants. So you need to get a license for your patents for whatever invention it is that you have. You need to get a license for it, and also having a non-disclosure or confidentiality agreement between employees and also partners. Can we move to the next slide, please? So what is trademark, which is the honors for this presentation? So trademark generally refers to, they could be words, they could be logos, they could be symbols that are used to identify a producer's goods. So basically trademark can be a logo, it can be a symbol that identifies a particular good from another. So for instance, if you see a Coca-Cola logo now, and maybe so instead of you seeing Coca-Cola on it, you see maybe Big Cola, I'm sure you'll be surprised because you're already used to the fact that, okay, this is the Coca-Cola logo. So that is what trademark does. It differentiates your product from another. And even as a business person, and even when we advise our clients, we should say, okay, whatever it is, when you trademark your logo, it actually helps protect and prevents other people from infringing on your trademark. So I'll move to the next, which is patents. So we give several definitions. If you see our presentation, we see that we give several definitions on trademark. Go back, Timmy. Yeah, so we give several definitions of, on trademark, please. Yeah, and in the case of Federal Limited and another, and Ibeto Industries Limited, it was stated by Mustafa JSC that the essence of a trademark, if that it indicates a connection in the course of trade between the goods and the same person and some person having the right to use the same. So basically, there's always a connection between that good and even the person that your clients, the person, your consumers. So more like there is something, when they see that logo, when they see that symbol that identifies your brand, they know that, okay, this is what this represents. And in an instance where you see probably another logo and you're seeing, probably you see a logo with another name on it, whereas you're already used to, okay, for instance, maybe you see an Indomie logo, and instead of you seeing Indomie on it, you see another name, you already know, okay, something is wrong somewhere because you already used the fact that this is an Indomie logo brand. So let's move to patents, please. Patent. So patent is a license that confers on its owner the legal right to use an invention. So you have the rights. So if there is an invention by a person, and maybe you invented a software, you invented something, there is a license that is given to you, and that is patent. So instead of being registered, like trademark that is registered, this one, you get a license for it. And the interesting fact about patents is that it is an exclusive right that is granted by the government to the owner. Please, I hope you're all following. Please, are we following? Okay, I hope we are. Yeah, and there are actually criteria for this. Yes, okay, thank you very much for the response. So there are criteria that needs to be fulfilled, because not just anybody could just come up and say, okay, I invented something. So and there are 3 criteria that are listed. It must be new, it must involve an inventive step, and it needs to be industrially applicable. So it doesn't just have to be anything, it has to be something that is new, something that no one has actually ever done, something that is novel, something that we've not seen before. So that's like one of the basic criteria for this. And can you move to the next slide, please, Timmy? Okay, another thing is that so beyond even protecting the invention, you can also protect the process. So the process for for that particular thing. It will be just the process that you're patenting. So you can actually patent that too. And we stated that the main reason to register a patent is to ensure that the inventor is able to exclusively commercially exploit an invention. So which is one of the very main reasons why it has been registered. Thank you. Can you move to the next slide? So the next slide, we talked about the differences between a patent and a trademark. So I'll just run through that. I haven't explained that earlier. So for patents, patent protects the creation or invention of humans. Like, so you're protecting an invention, while for trademark, in trademark, you are actually protecting your brand. So it's actually helps to distinguish a particular brand from another. And for patents, its registration lasts for 20 years, while for trademark, it lasts for 7 years. While for patents, another point is that it is in all cases, it needs to be registered. For when it has to do with the registration for patents, you have to register it. While for trademark, it is actually not in all cases that you register. And the registration process for both are actually very different, which is why, which is also another major difference between the both of them. And lastly, it has a longer period of, sorry, I can't really see that. Okay, yeah, it has a longer period for expiration, and while trademark has a shorter period of expiration. Please can you move to the next slide? Okay, thank you. So the next slide, we talked about examples of a company that registered their trademark and gained revenue. So I'm sure we'll be wondering, okay, how can a company gain revenue with trademark? So from my research, I got that, okay, you can actually get revenue by registration, either by license, when you decide to give another person or probably another company exclusive license over that particular trademark, or by transfer, you can transfer your trademark registration to someone else and you get money, you get revenue for it. And also it could be used as a collateral. And we gave examples of companies that have registered their trademark and gained revenue. And the first one we gave is Google and LG. And Google, they got some of about 44 billion pounds from its trademark, and also LG got what an high amount of money for monetary benefits from their trademark. Thank you for that. Please move to the next slide.
You can start rounding up.
Okay, thank you. Okay, examples of businesses that didn't and lost revenue is Pin Interest. Pin Interest, they didn't register their trademark and they lost revenue on that. Please, the next slide. So for patents, examples of a business that registered their patents and gained revenue is IBM. And IBM means International Business Machine Corporation. So that company also, they registered their invention, they registered their patents and they gained revenue for that. Please, the next slide. Okay, yeah, and examples of businesses that didn't register their patents and lost revenue. So basically, the essence of all this is you need to register. I just talked about the essence of you registering because you're protecting yourself from losing money and gaining revenue. And as I conclude, I hope that with this explanations, we now understand that, okay, intellectual property is actually a business, and you protecting your business, you need to register. So if it's an invention you have, you need to register. And if it's a trademark, probably a symbol you're trying to protect, you also need to register it. Thank you very much for listening to me. Please, can you move to the next slide? We have questions from our group, and the questions we have that we'll love our mentors to help us with.
Later. We'll take the questions.
All right. Thank you very much. Thank you.
Thank you so much, Adidamola, for that awesome presentation.
Nice presentation, yeah.
Thank you, Ma.
So move over to group 2. So the representative of group 2, you're ready. Group 2, are you ready? Group 2 is not ready. Group 3 can come on board. Or group 4. So who are the representatives of the various groups?
Good evening. I'm representing group 3. Should I go on?
Yes, you can.
Can everybody see my screen?
Yes.
Yes, we can see your screen. We can see your screen. Thank
Okay.
you.
Good evening, everyone. My name is Wampo Ifechimelu. I am the professor for Group 3, and I'm going to be talking about the various means by which companies and individuals generate long-term revenue using their intellectual property. And I am going to be discussing three major ways, which is licensing, IP franchising, and IP export. Yeah, so first of all, I would like to break down the concept of intellectual property. So intellectual property refers to creations of mind and are also intangible in nature. They are inventions, literary artistic and artistic work, designs, names, symbols, etc., which are used in commerce. There is a intellectual property law, basically law or body of law that seeks to protect human property and properties, intellectual properties, or rather properties of human creation from unauthorized use by third parties. Moving on to intellectual license. Can an intellectual property be licensed? The answer is yes. Can be licensed, and there's a law that backs, this affirmation. What is intellectual property licensing? Intellectual property, it is one of the major ways by which businesses and individuals that own intellectual property and license can generate long-term revenue for their business. Intellectual property licensing is the act of entrusting an IP right to a third party for use, excluding ownership of such. How it operates basically is that the intellectual property owner, who is known as the licensor, receives payments in form of royalties for granting another person known as the licensee, who is the third party, the right to use their intellectual property. Another perspective for understanding intellectual property licensing is that it can be likened to leasing of intellectual property for a fee. This is quite unlike intellectual property assignment, which transfers all ownership of intellectual property to the third party. IP license only provides limited use and seeks to protect the ownership rights of the licensor. There are three benefits of intellectual property licensing. It protects the ownership rights, which I have mentioned earlier. It promotes the business brand, and then it also serves as a form of profit making, in the sense that this agreement, royalties are profit. An example of a company that has license, example of an intellectual property licensing agreement will be the agreement that was made between Nestle and Starbucks in May 2018. So basically, that licensing agreement, in that licensing agreement, Nestle obtained license from Starbucks to sell their products, their tea bags, their coffee, and all of that, to market their products for them. And they were paid the sum of, Starbucks was paid the sum of $7.5 billion by Starbucks was paid the sum of $7.5 billion by Nestle company. So that is an example of intellectual property licensing agreement. Now we're moving on to the second way by which businesses can generate long-term revenue for their business, and this is called And this is called the concept of franchise. Sorry for that interruption. Benefit of, the concept of intellectual property franchise. A franchise is a license that a company purchases from another company, allowing them to use another company's name or trademark. That's basically the concept of franchise. Franchising agreements are generally specific in nature, and the contractual relationship is one where the franchisor allows the franchisee to use its business model as a basis for operating their own business. Examples of companies, franchising are very common. A very common companies that we see in Nigeria today, like Mr. Beast, Domino Pizza, KFC, Domino Pizza, etc. Companies are into franchising agreements with the real owners of these businesses. They are abroad, who are abroad. The third way by which we can generate revenue as a business or as an individual using your intellectual property is IP exports. IP export simply means to trade intellectual property in international markets with foreign customers. It is important to note that although IP property protection is jurisdictional, the owner of the IP who has the intention of exporting must apply for intellectual property rights in the country where he or she intends to export. And a good example of IP export is where Nollywood movies are exported to Mexico. That's a very good example. Yeah, so this brings me to the end of my presentation. And thank you so much for your time and attention. Wow.
Thank you. So we know how we can get money from So before we move over to group 2, for the mentees, I encourage everyone to edit the name on their profile so that we can see your names and see the persons that have joined us for meeting today. Because I'm sure I'm seeing a phone device and that's not someone's name. Please let's try and edit our names. So the representative of group 2. Group 2, please, your presentation.
Good evening, ma'am. I'm ready.
Good evening. You have 8 minutes for your presentation.
Please, you can go ahead with your presentation. Thank you.
Okay, thank you, ma'am. Good evening, everyone. My name is Adiko. I'm a member of the 2 and I'll be handling our presentation for today. So our topic, the part of we are talking about what is called copyrighted works, examples of copyrighted works, and then why the business register their. So copyright, first of all, let me explain what copyright means. Copyright is the legal right which protects the creator of a work and allows you to enjoy the proceeds. So as an artistic person, if you are into art or any work, any artistic work, copyright allows you to enjoy, allows you ownership over your work, and then allows you enjoy the proceeds from it without anybody stealing or reducing your profits. Yes. So for your work to enjoy copyright protection, it must satisfy the requirements of originality. It must be original. You cannot copyright something that looks like another author's work. If there is, it cannot be similar to another author's work. It must be original to you. And also, examples of copyrights, works that can be copyrighted include musical works, artistic works, cinematography films, sound recordings, and broadcasts. Also, I'll be defining industrial design. Industrial design is defined in Section 12 of the Patents and Design Act 2004 as any combination of lines or colors or both. And basically, industrial design establishes the identity of the product. In industrial design, the essence of registering your industrial design, it focuses on the outlook of a product. For example, a Coca-Cola bottle is an industrial design. Just the bottle is a design. So registering it is just focusing on the outlook of the bottle, not the wordings on it or anything, or the colors or the writings or anything on the bottle, just the way the bottle is designed. That's the essence of registering industrial design. So it means that whatever original design that you come up with, it must be original to you. It must be new. It must not be something that has been in the public before. It must be new. It must be original. And benefits of copyrighting your work is that you will enjoy the revenue. The proceeds belong to you alone. And then benefit of registering your industrial design is that it's provision of exclusive rights, revenue generation, ability to litigate, and then production differentiation. I'll be explaining that one by one. Number one, provision of exclusive rights. It gives you, when you register your industrial design, it gives you exclusive rights over that design. You have the right to do and undo over your design. You have the right to make decisions over your design. And then revenue generation. You are the only one that can decide what you want to do, how you want to generate revenue over your design. And number three, ability to litigate. So in case there is an imitation of your industrial design, you are the only one that can bring an action to sue whoever is imitating your work. Another person cannot sue on your behalf. You are the only one that can litigate concerning your industrial design. And also product differentiation. It allows for differentiation of different products in the market. So if you know, for example, Coca-Cola bottle is different from Pepsi bottle. When you get to the market, you know, okay, fine, this is a Pepsi bottle, this is a Coca-Cola bottle, this is a Biggie product. You know, it allows for product differentiation. So there are examples of cases that businesses that did not register their industrial design and they lost revenue concerning that. A popular case is the one in Apple against Samsung Electronics. In that case, the court was unable to grant injunction to Apple because why? They were unable to prove if their design was actually new. So if their product was actually new, if their design was actually new. And like I said, when I was defining industrial peculiarities of industrial design and copyright work, is that it must be original to you. It must be new. It must be a new idea. It's not something that has been in the public before you can register the design. So also, another business that gained revenue from registration of their industrial design is Chukwumereji Ije and Sons against Partcom Industries Limited. Examples of businesses that lost revenue due to their lack of not registering their industrial design in Metropolitan Industries Nigeria Limited against Industrial Application Limited. That is all. Thank you very much for listening.
Thank you so much for your presentation.
Thank you.
The benefits of registration of intellectual property rights. So finally, I think we're left with group 4. So group 4, if your representative is ready, you can start your presentation now. Remember, you have 8 minutes for your presentation.
Good everyone. Can you guys hear me?
Yes, you can.
Can hear you.
All right, thank you very much. Good everyone, good evening. My name is Philip Wonsu, and I'm presenting on behalf of Group 4. Thank you very much once again. So our topic for discussion is intellectual property in businesses. And for this purpose, and for the purpose of our discussion, our topic is actually dichotomizing to what is IP, then the definition of intellectual property management, the definition of intellectual property violation, and also trade secrets. So my discussion will be limited to these 4 areas. So quickly, intellectual property has been defined by so many authors, but fundamentally by WIPO, that's the World Intellectual Property Organization, defined IP as a creation of our intellect, which includes patents, which includes copyrights, which includes trademarks, etc. So basically, IP has to do with the creation of our mind, intangible assets that springs from our intelligence, that springs from our brilliance. So it covers areas far above trademark, far above patents, far above what's the called, far above inventions and the rest. So it's a broad ask about anything that has to do with the origination of a man's mind. That's basically or briefly what IP means. So going on, we'll move swiftly to what is intellectual property management. Remember, our topic is intellectual property in business. So what is intellectual property management? So I'll for the purpose of like briefing the statement, I will just call it IPM. So IPM basically aims at generation of intellectual property, protecting intellectual property, and leveraging same into the market for the purpose of increasing revenue. So as I said, IPM, that intellectual property management, has to do with the generation of intellectual property, protecting intellectual property that has to do with copyright, that has to do with trade secrets, that has to do with patent designs, etc. For the fundamental purpose of bringing into the market, bringing into a business firm, bringing into a company to increase its revenue. So basically, I feel what blood is to our bodies is what like a proper IPM is to a business, because without a proper IPM in a business, the business will actually be like characterized with so many disasters. So for instance, if I have a business and I don't really have a proper IPM team to manage my intellectual property, I might go on a project of my own. I might mistakenly go and use the trademark of another company in the same business sector as I am as me. And definitely this would be an IPR infringement and it would make me vulnerable to territorial litigations. So the relevance of IPM cannot be underestimated. And the fundamental purpose is to help a business to manage it, to help it to manage its intellectual property, to avoid issues of IPR infringements. So there's a distinction between IP management and IP administration, although the both terms are quite alike. So an IP administration deals with IP assets, which focuses on the acquisition, preservation of all legal and all legal aspects. However, the central task of IP management is the integration of intellectual property into an innovative strategy and business model. So the essence of an IPM, that's intellectual property management, is for the purpose of increasing the business outcome, for driving profitability into a business, into a company, bringing profits, maximizing financial benefits, attracting financial gains into a business. So we'll just move swiftly to the benefits of IPM, that's the benefit of intellectual property management. So the benefit of Petora, I'll focus on just three. So the first is it establishes an IP ownership. So through the help of a proper intellectual property management, firms, companies, businesses, small business enterprise, etc., are able to they're able to be notified. They get knowledge as to the ownership of several IPs in their respective industries in order to forestall IPR infringements. Secondly, it helps update competitors of IP infringement case. It helps update competitors of IP infringement case, and it also helps to provide information about IP to the general public for public consumption. So these are the fundamental benefits of an intellectual property management. So it's very important to know that failing to protect an IP could cost a business great sum of money, and it can also lead to the closure of a business. So the relevance of IPM cannot be underestimated, and every business enterprise, every company, every organization is encouraged to have a proper IPM, a proper intellectual property management in their respective industry. So there are examples of businesses that have managed their IP for revenue gain. And out of the many examples is the Apple company. So Apple offers cloud-based patent management system to enhance productivity through collaborative automation tools. So this said company actually have a very strong IPM, and by virtue of their well and properly organized IPM, it actually led to generation of massive funds, massive revenue, up to the range of $721,000. So move to the next content, which is IP evaluation. So firstly, IP valuation is the process of determining the monetary value of an IP asset. It is the process of discovering what is the monetary value, what is the financial value, what's the economical value. Say that I actually wrote this storybook, which is the copyright, which is under copyright. So what is the financial value of these said IP assets? And in order to achieve this, there are so many methods that are applied. There are so many methods that can be applied to determine the cost or to determine the value of an intellectual property. So we have three basic methods, which includes the income method, the cost method, and the market method. The income method, the cost method, and the market method. But before explaining that in detail, it's gratifying to know that the value of an IP asset is measured on its ability to generate financial value for its owner and to enhance the value of other associated assets. So the value that will be invested, or the value that will be characterized on an IP asset, is measured on its ability to generate financial value for its owner. So if an IP cannot generate value for its owner, then it will be a valueless IP, and I doubt profitable. So quickly, we have three methods of IP validation: income method, market method, and cost method. So the income method is the most commonest method. So it has to do with the expected amount of money, the expected amount of. All right, okay. So I'm rounding up now. So trade secrets. So firstly, trade secret has to do with informations that are unknown to competitors in a particular industry. So there are information that are solely under the knowledge of a particular industry, which is used for the profitability and which is used for the purpose of manufacturing items in that industry. So for a trade secret to be a trade secret, first of all, it should not be something that is subject to public consumption. It has to be subject to the knowledge of the industry that accommodates that trade secret. So for a trade secret to progress as a trade secret, the owner of the trade secret has to take diligent steps in making sure that the trade secret is not within the custody of the public. And one of such ways he can achieve this is by a non-disclosure agreement with his respective employees in his industry. Lastly, or in conclusion, trade secrets are actually different. They are not really subject to, they're not copyrightable and they're not patentable. So there's no formal procedures for registering a trade secret. What is just relevant is that it's something that should not be subject to public consumption. It should be something that should be exclusively within the title and awareness of members in that particular trade. So I will just mention one company who has a very, whose trade secret has, I'll just mention a company that has demonstrated the relevance of trade. All right, so Coca-Cola and KFC, etc. So this is all for our presentation today for Group 4. Thank you very much, and God bless you.
Thank you so much for your presentation. We now know the importance of having an IP management team and the importance of managing our intellectual property rights.
Sorry, we can't really hear you well, Amaka.
Oh. Can you hear me?
Yes, we can hear you.
Okay. I was thanking Group 4 for their awesome presentation. And then quickly we'll be going off to our mentors. I want to hear their thoughts and then their observations, as well as recommendations for our presentation. So first up, we'll be going to Nirvana talk. Ma'am, please, can we get your thoughts and your observation?
Good evening for all, and nice to meet you. And I'm very glad to share today with you my insights about this very interesting presentation. I really enjoyed it with new information for me concerning Nigeria, especially trademarks, devices, applications, markets, events. I remember something bigs, like Mac Big, something like that. So I go to the website, I have a look. It was very interesting and new information from me that I really respected. So let's start by the presentation. I will share with you, just a minute. Yes, the first one concerning the first group, it was intellectual property for business. Yeah. This is full of information and very interesting that I really appreciated, and and especially there is no more comment. I have only this in the benefits of IP management to business here. I mentioned that we have to add also that business action is very important to stop counterfeiting and piracy, especially this is in our digital life. Everything is digital now, so we have to take care of this because there is a lot of counterfeits that I face in my job, also in my life with my family. So we should take care of this point and add it with examples. Sure, there is examples that the presenter can add for this presentation, but as a tool, it's good. Yeah. I like the app call, and I go to try to have a free trial with the application call. It's very interested, and I like it. Yeah. The evaluation is very important. As WIPO have, I think that the presenter here is interested about the DL for 45O of WIPO, as I mentioned, and give big interest in the valuation of IP, like the profit, the market, the study of the costs. Is the 3 points which is very important in the making the valuation of IP assets. Here, concerning the continuation when assessing the value of an intellectual property, it is essential to first conduct the diligence to determine. So I add some comments, like the goal is to access depth, scope, enforceability, ownership, and future potential. That IP due diligence also gives the buying and selling company the chance to access which intellectual property assets are being sold and which are not. One of the goals of IP due diligence is to avoid risk, which is very important, avoiding risk in this point, in order to have more benefits and decreasing the danger and the risks that can be happen during our process of the intellectual property and the evaluation of intellectual property process. The overall of balance. Yeah, I like this device also, and I go to the website to check it. Conja, yes, Conja and Udala. It's like here in UAE, Amazon, and Noon, and most of Arab countries, even Egypt. So it's like these devices, which is very common in our life now, and all people make orders through this device. So it's very important to have something like that. And this is brand names that should be protected and have big value. Yeah. 7 million, so it's worth big value. Yeah. And there are also Jumia. Yeah. Concerning this UTSA, I go and check, especially for because USA is very interested in trade secret, and I think one of the most trade secrets in USA is Kentucky, and then the secret of Coca-Cola and the mixing. If you know the story of Coca-Cola, it's 2 engineers that each one they didn't know each other, and they go in different time to make special content of chemical or not chemical. Yani we said chemical, but it's not many chemical, but some grades and contents of the components of Coca-Cola, and the other one came in other time from another door. put the other content, so they didn't know each other who put what. This is the secret of Coca-Cola, which has doesn't belongs many long ago. I add something for UTSA is a non-profit organization and defines trade secret and describe claims related to trade secrets, especially in USA and I think Europe. They're very interested in this. We hope also we have trade secrets in our countries, in Africa, because it's very important, because it needs money, it costs, but it's very important that we make a secret for our know-how, because I'm sure there is a lot of know-how in African countries, but the technique, the steps, the awareness, the money, all of this stops us from this protection. So we should, academies, universities, government, non-profit organization should support these students and these people, this entrepreneur, these small and medium businesses should be supported by these people to support them to protect their know-how. It's very, very important. I hope to hear something in Africa as somebody as protect his know-how and his trade secret. Okay, I think it's very interesting, and I think there is a lot of these ingredients. It's just a picture because Kentucky will not put his secret like this, because we can know these ingredients. And I'd like to thank this group. It's very interesting, really very, very interesting subject and full of interesting details also. Okay. So can we return back to the other organized presentation? This is group 2, I think. Also intellectual property for business, group 2. Copyright. Wow, it's very interesting. I love copyright because it's in all our life. There is copyright, really, and we should protect it and take care of it. And it's easy to protect it, and it's not costly. It's not costly like patent, like trademark, like international registration of trademark, like trade secret. So copyright is less expensive. Digital design. Yes, copyright is for books, photographs, dramatic works. Yes, for this, copyright is in all our life. Even the registered marks, they should be protected at the same time as copyright. Some patent, they should be protected also as copyright. Copyright is very important, and should be aware of this one. This is very interesting style of comparison that I like it. In this presentation, that there is many comparison between the business that gain revenue and the business which lost his protection. About this company, I tried to check it on website, but I didn't find it, all of them. Okay, we see here that not being copyrighted, so he lost his rights. Yes, exclusive rights, sure. Protection by the parties that and revenue. So also the industrial design, which is not Bardo, is not expensive like trademarks and patents, and it's related to creativity, innovation, thoughts. It's very nice, interesting, but short-term protection. But it's nice to have all the time to create, to have new. This is the main point of industrial design. However, the trademark could last forever, be inherited to other generations, and we'll talk about this in the trademark registration presentation. Sorry, ability to litigate and when a design, sure. But as I said, that the duration of designs is not long, from 10 to 15 years. So it should be renewed for one time, only like the patent. So the time we don't have to make, if it doesn't matter to go to the courts and make arbitration if it's costly, because as I said, the expiration and duration of design is not long. However, the trademark, we should never let our rise, because it's renewable each 10 years and could still forever, the trademark, as long as we renew it and protect it. Product differentiation. This is very interesting also, I like it. It's comparison between Apple and Samsung. And there is two comparison each other when Apple lost his designs in the court, and the other one when it accepted management. I like it. Very nice, very interesting. Thank you. So let's go to the other presentation. This is group 3, yeah. Yes, the licensing is very, very interesting subject, and as I am during my master, I make my paper concerning the licensing, especially the franchising. It's very, very interesting for me, and I think it's very important for business, even for developing countries, for entrepreneur, for small and SMEs, and also for a startup business. Very, very important. But we should support it, as I told before, by academies, universities, non-profit organizations. All these should support people, and entrepreneur in the beginning can make license. It was very, very interesting, and protect the the IP for a long time with new areas and geographic areas, which is very interesting. I like the lesson, especially the franchising, really. So simple. Kentucky, McDonald's, sorry, even the shops, fashion like Vuitton, Mont Blanc, Christian Dior, all of these have licensing in other countries, yeah. Yes, this is the royalties here, like patents, they have royalties, and they have many licensing for, it could be, there is many kind of licensing. One of them that I like it, which is the licensor can give a licensee for many licensing in many countries, different countries. So it's good, very interesting. It's open new business for these people, for this startup, for benefits for both of the licensor and the licensee also. But the agreement here, the contract should be well prepared and organized, and in order that the rights of licensee are completed without losing his rights, because sometimes the licensor didn't give the licensee all his rights in this contract, especially of the licensing. So should take care of somebody if you would like to do this in the future, inshallah, to read well this contract, because there is some tricks that they should take care. Sometimes the licensor enforce them because they know that they want to gain more money, more relationships, business, startup, maybe it's young people, so they put some tricks in contracts. We should take care of this. It's very important, because I faced some cases my job and my life, and I know many cases in this, even in Europe and in many countries. So this is very important point. Yes, sure, protecting the ownership rights. Yes. Franchising. Yes, sure, yeah. Is a franchisor and franchisee. This is part of very important. This agreement take care of this tricks, my point of view, and take all his rights from the beginning. It should be written in the contract in order not to cancel this contract at any time, because there is sometimes force majeure in the end of the contract, which is force the franchisee to leave business and lose his money. Mr. Biggs, I check it, very interesting. Here I add for the IP exporting is very interesting subject also. The advertising, marketing, participation in fairs, packaging, pricing, and patterns. There's a lot to discuss in this subject, which is very, very interesting. The exporting, the IP exporting should be a subject. And we can make a presentation only for the IP exporting. It's very, very interesting. And I can help you if you need anything in this, because I have many studies in the IP exports. Yes, thank you. Let's go to.
Thank you so much, ma'am.
Thank you. Unless you don't need, okay. We don't need to discuss this subject.
Thank you so much, ma'am.
Okay, okay.
We'll be taking other mentors. So at the time of the question and answers, you can also chip in the other points that you discover from the questions.
Yes, the question, yeah? The question of.
Yes, ma'am. After the presentation from other mentors.
After the presentation, okay.
Yes, ma'am. Thank you so much.
Thank you. Thank you, dear. Thank you.
Okay, we'll be heading to Uche Mokoja. Ma'am, the floor is yours.
Thank you. As a first off, let me just thank all the presenters today. All the 4 presenters, 4 or 5, did brilliant work, detailed research. I doubt if I would have performed like it did when I was in that level. So well done, people. You did fantastic work. So now I am not here to review your work, but at least to chip in a few points in addition to the fantastic work you've all done already today. So the first speaker, Mr. Detula, had mentioned registration, licensing, confidentiality. These are the ingredients of protection that is really key. But for patents, you had said that what is given is license. I'd like to correct you that license is what is given by the licensee, the owner of the license. License is what is given by a licensor, and it had nothing to do with the owner of the patent, who is the patentee. He is the true owner. He can give license to somebody else, but he is the true owner of the patent. And what the government gives to him is called the letter of patent, and is valid for 20 years, subject to annual fees. So if you pay annuity every year, it remains valid for 20 years. After 20 years, it goes to public domain, which means that somebody else can work it because they don't want you to monopolize. But then some companies, especially pharma companies, have found a way out by, when they're getting close to the 20 years, they can vary a few things, because about drugs, new things keep coming. It's an invention, and they can vary it. And if you vary it, then it becomes new again. It's not been done before. Then you gain another 20 years. And it's good because that means they will keep drugs in the market with the new innovations to keep all of us well. But when you had mentioned, Mr. Detula, that that trademark lasts for just 7 years. No, it doesn't. It actually lasts forever. So long as you renew it, it's better than, I mean, if you want to keep your intellectual property forever, trademark is the way to go. But then there are two different IPs, but you enjoy it forever, so long as you pay your renewal fees. In Nigeria, it's 7 years first renewal, then after that you do 14 years. Just keep renewing it until you get tired, or you license it, or you assign it to somebody else. It's actually, like they say, the renewal is infinitum. Then with the patent, as against trade secret that you mentioned, with the patent, you have to give details of your patent to see all those conditions that you listed, novelty and all of it, industrial application. But with the trade secret, you cannot, because the only thing that gives it value is the secret. So all you need to tell the registry is that you have a trade secret, but you don't have to disclose, because if you disclose it, then it's out, then it loses in value. So no details are required with respect to trade secrets. The license is issued by patentee to a third party, to work it for an agreed term. It might be for 2 years, it might be for 5 years, but the ownership still remains with the patent owner. So off to the second speaker, Ms. Nwafo, you had mentioned licensing and franchising. I try to distinguish the two, because whilst with license, you can license your trademark only. With franchise, like you rightly mentioned, Domino, and the whole of them, you actually give up your name for a good number of years. It might be for 10 years. Usually when I review agreement for franchisees and franchisors, even though NOTAP will require you to do the first 5 years, but usually if it's a major thing like that, I mean, by the next 5 years, it's still a teaching period. They are trying to know the jurisdiction that they came in. So oftentimes we try to push for 10 years. But the danger here is that once the franchisee gets a hang of the name and enjoys it, they find it very difficult to give back to the franchisor, the owner of the mark. Take, for instance, okay, Domino, I'm not saying that's what's gonna happen. But oftentimes you find out that the franchisee has now made the business known within jurisdiction. Because remember that the reason franchisor came in the first place was because they want to extend their business to another jurisdiction they have not been in, and they need a local operator to do it. So this local operator that becomes now the franchisee will now get a hang of it, start enjoying it. At the end of 10 years, they refuse to give up the name because people have known them with that name. He can't go and change it and call it more for a shop. No, it has to be with that name, Domino, for the sake of argument here. So oftentimes you have to put things in place. That's why when you're doing franchise agreements, even though there's no legal framework for franchising in Nigeria, so oftentimes we mistake it with licensing, but you have to make sure that the agreements are really, you provide all the details, because otherwise you find out that when the franchisee starts enjoying the money, he doesn't even pay royalty, what he's supposed to pay to the franchisor. So agreement is very key in this. So that's the main thing that I like to correct for Ms. Nwafo. And the third speaker, Ms. Nwaeli. Oh, you talked about design. Then you talked about the bottle, which is right. We always use the Coca-Cola bottle because that is one design, 3D design, that is really accepted in Nigeria because it's so unique. Oftentimes you close your eyes and you touch the Coca-Cola bottle. They call it the contour bottle. You feel it. You don't need to open your eyes to see that this is Coca-Cola. So they are giving that privilege in our trademark registry. So But the get up is also key, which means color. I mean, Coca-Cola and that red color that they put in, it's very key. So you need color. When you were talking, I wasn't sure if you were, I think you were a bit, whether color is included. It's very key because color is what makes the get up what it is. You have to look at all the exterior designs and then with the color. You know that, for instance, Cadbury has the purple, you know, so you have corporations holding on to some colors and are known with that color, and Coca-Cola is red, amongst others. So, and then to the fourth speaker, Mr. Nwosu, you talked about businesses, yeah, how intellectual property can help businesses, and I totally agree with you. Oftentimes, what we talk about is the traditional intellectual property, trademark, patent, design, copyright, but we forget the other intangible ones that are called intellectual capital. Take, for instance, you have an IP expert in a law firm or tax expert. He knows how to save money for people, not telling them not to pay tax, but he will give good advice, make certain deductions that will make their clients enjoy and gain value from them. So this is know-how. And oftentimes you can find it in the financial books, but it's there because they earn fees. In my office, for instance, we have budgets for individual partners and we know the fees we bring in. That's, you bring in value. And people come to you because you give a particular opinion that will get them value, get them where they're going. So it's very important, those know-how. And data, the data, big data sitting in some companies that they don't know. They haven't seen it, but it's money. And once you see it and work it, it becomes money. And also business model, he mentioned business model. And also IT. Take for instance, if in your various offices, IT does not work for a day, the whole office will shut down. You will lose things, and then hackers might even hack in and take the name of your client or some secret documents. So it's very important, this know-how, and it's heavily protected by confidential agreements in place. So oftentimes you find out that you leave your company and the company will let you sign an agreement that you can't work for their competitors for 2 years. Some people see it as harsh, some judges will not agree, but it makes business sense. If, for instance, I'm in a deal and I'm representing company A and company B refuses to sign confidential agreement over a trade secret, at least there's no deal, because I can't really start a business with you knowing that tomorrow you're gonna walk across and take the secret to some other person. So finally was the last speaker that talked about valuation methods, very key. I mean, I'll just mention, the market value, you look at the cost of similar products in the market. It's always good to check what is iPhone costing as against Samsung. So you look at all of those. But I think income valuation is one of the best because it's a bit futuristic. You just look at the cost of replacement of that product, and then you look at it. If you can replace it at that cost, fine. If you cannot, you need to make accommodation for all of those. So these are my comments. Outside that, you guys did fantastic work, and I oftentimes when I join, I learn from you all. Thank you so much for having me today.
Thank you so much, ma'am. Thank you. Thank you for finding time to join us and for your wonderful observation. So finally, we'll be moving to our next mentor, Mr. Max Ikobe.
Okay. Good evening, everyone. I hope you can hear me.
Yes, I can hear you.
Okay. Okay, my apologies because I'm using headphones. I don't know how. I hope it doesn't interfere with my voice where I'm a little bit noisy. But let me first start, of course, by thanking Juliana as always for inviting me to be a part of this program. And of course, welcome this new cohort to the JIIPCC Mentorship program. You are actually in the right place. I've been a part of this for a while now, and I know the job this mentorship is doing is something that's going to really change the face of IT, practice in Nigeria and of course in Africa. And of course, I want to thank the other mentors as well, Rana, and then of course the madam, like I always say when I talk to mentees here, the opportunity you have of having access to someone like you, which I suppose is very serious because in the IT world, where people like us are considered the magistrates and the lower court, people like Madam Ucho,
Thank you so much. You're very kind.
Sorry, please, can we hear Mr. Max?
No, I can't hear.
I can hear you.
Okay.
I can hear you. Go ahead.
I'm not here, Mr. Mark, please.
Sir, we can't really hear you. Maybe because of the earpiece. No, sir. No, sir.
Okay.
We can hear you now. So I heard you like for a bit, then it went off again.
Okay now.
Yes, sir. I don't know. It's like it's.
My apologies. Yeah. The internet where I am is quite dodgy.
Okay.
Okay, so apologies for that. I've done a wonderful job, drawing from representation. I would not just add one, just to make some distinction when you spoke about trade secrets, which is helpful from an P in business, is look at trade secrets. Trade secrets can be any information, economic value attached, to your and that you have kept efforts to keep secret. So don't always low level things. For instance, of a trade secret protection, because if somebody to effectively contact your as something that you can protect by way of copyright, you can protect if you keep it secret. For instance, list of your distributors, information, because sometimes what gives you the edge is to give you better prices than what out into the public. You might be losing some the market. Then also it's important to note that if your opponent is able to get a hold of without actually stealing it from you, then for an infringement, as it were. So some products that people can easily reverse, look at and work out the trade secrets. So if you notice trade secrets, for instance, in the food and beverage sector, you can't easily, maybe Coca-Cola, for instance, able to get the process that Coca-Cola protects, and security great protection. So you just need to understand every business has them. Some businesses may not have their line of business is not really doesn't. Every business has trade secrets. That is just the simple. That when you go into advising a business is to quickly those information they have that are either proprietary by that business or common knowledge that other people know, but the way other information has become proprietary. So you could value as well. So I think I'll pause. We could have enough time to tackle the questions. Thank you.
Thank you so much, sir. Thank you. Thank you to the mentors. So before we move on to the question and answer segment, it's picture time. Please, we implore everyone to turn on their video and then take a screenshot of themselves and post on LinkedIn afterwards. Hashtag JIIPCC Mentorship Program. Okay. Can everyone hear me?
Yes, I can hear you now.
I didn't quite get the last
So
thing
I
you
said our
said.
first question.
Yes, ma'am, we can hear you.
Hi. Can you hear me?
Our first question is,
Okay.
can patents be renewed? So the question is directed to any of our mentors.
Can I have a go at that?
Okay, please go ahead.
Yes, sir.
So if you recall, you don't necessarily renew them. What you pay. So once your patent is granted for 20 years, but to keep that alive, I've used that word. So it's not exactly renew an annual sum you pay to keep that patent alive. And once that 20 years is, however, that also what the law says. Also considering that now there's what they call patent grant. In the course of getting your patent for certain products. And so an example is where you are doing a clinical trial to wait 4 or 5 years to get clearance before you can actually get in the drugs. So an extension to cover up for that time, administrative clearance and such other things. It's enforced in a lot of countries and in the amendment of the patents and designs. It's possible to get a patent grant and not renewable. However, there are other some of them are not exactly ethical. Green, where you could have when a group that for a new invention or an improvement patent expires, you improve you can get a new patent that lasts for another 20 ethical that is called evergreen. And 3 years into the marketing, they should normally get that. And therefore they'll be getting an extra 3 years because they years. But what some people do is to hold back that year when their patent is almost due version, and then they get a fresh 20 years. Your competitors after 20 years, like Mr. Moko, and work it and begin to produce. But the difference is that with your new advantage, because customers will always want to go for the. So that could be an unethical. But by law properly, there's trademarks can be renewed, but certainly not patent. This way that people use to extend their patent rights.
Thank you, sir.
Can I add my answer, please? Juliana?
Okay, ma'am.
Yes. Concerning the first one, which is what considerations should I have when planning an IP strategy for a new market? I see that it's very important to make a study to understand more about this whole market as an economic environment. This is very important to study, make a study, survey before anything, their strategy, my competitors in this market, and other influence factors like price, like maybe there is a political bad environment. This is very important, yeah. And make an evaluation after that of my intangible asset, the IP asset, to know its real value after all of these factors, okay? My expenses to invest, how shall I put in the market, how it would cost, really evaluation, yeah? And it is competing to me to get more profits and benefits from this market or no? These very important questions that I should ask myself before go to this market and make an IP strategy or invest in this market, okay? This is the first one. The second one, how to determine the value of IP of a thriving business. I think this is when I don't have, in the case of, I don't have the experience or the whole experience that I need in this case, it's better providing experts in this point, especially the evaluation of these intangible assets, which will make their studies, their own studies and surveys, which will help me to know more about the value of IP of this thriving business. The comparisons, the strategies to guide me and determine the value or the real value of my intellectual property in this thriving business, or maybe not. So this is question. I'm not sure it will be thriving or business or no. So I should have provide experts in this case in order not to lose my money for giving open market and have more clients, more customers, and I will lose my money. So it's very important to determine this value, but listen to the experts, make comparisons, put strategies, and their studies and my studies also. If I can make studies by myself, I have the experience to make it, it will be important also. So this is the point to determine the value of IP. Thank you.
Thank you, ma'am.
Thank you. Thank you.
Oh, okay.
Let us find out if any of the men have any question. I think that if you have a question, you can just raise your hand up and we can call you to ask your questions so that we can get live questions since the time is already going.
I have first one comment, please, Juliana, concerning trademark. There is a presentation about trademark, and the students write that it's 7 years. No, it's not 7 years, it's 10 years. The renewal of trademark is 10 years. As local and as international, depending on TRIPS. It was Paris Convention, then TRIPS, then Madrid Protocol. So it is, even it's local or international registration for trademark, it is for 10 years and it could be renewed forever, as much as we take care of renew this trademark before the grace period. And there is grace period for 6 months. Before, and there is 6 months in the end of these 10 years that we should protect and renew our trademark. It's a very important point. Thank you.
Thank you very much, Niven. I think when they refer to 7 years, it's according to the trademark law here in Nigeria. Sorry, the trade
7 years.
Yes.
Yeah, it is 7 years. Only because Nigeria has not signed to Madrid.
This is this point.
Yeah, so it doesn't apply in Nigeria. Thank you so much.
I have my comment. Okay.
Thank you, Ma.
Thank you.
Okay, so Sandra, I think that you can just call those that have raised their hands up. Let us just take live questions from them.
Oh, okay. First on the list is Tijani. Tijani, your question.
All right. Good evening, Ma, and good evening, sir. I appreciate everyone for the lecture so far. So my question is, I don't quite get the difference between licensing and franchise. I just want to be clear on that, Ma.
Okay, I will take it. I'd even put the answer on the chat. So with licensing, it's a more a simpler one. An owner can license their trademark. That's all. It's very simple. You lodge the agreement with the trademark registry. Sometimes it's called registered user agreement, so that they will know that this person is on record, and then the registration does not die. They keep it alive. But with franchising, it is a more difficult one because it had to do with business. You're actually using a company's business model, their name, everything about them. And you don't go to trademark registry, you go to NOTAP, because they look at how you're going to transfer technology, transfer all your method of doing business, and they register it with central bank because they don't want you to take money out of the country if they have an alternative, that somebody local, you can do what you're looking for locally. So the only reason you bring it from outside is because we don't have the technical knowledge. So if you bring it, you register it with NOTAP for maybe 5 years or 10 years. Then, like I mentioned, you use the name, not just the trademark, like Domino, like the other one, Kentucky Fried Chicken, all of those. So, or if McDonald's comes, it's the same thing. So you use their name. But with license, you don't use the name. You just use the trademark. Nobody will even know. Only the registry will know that Mr. A has issued Mr. B a license. That's the main difference.
Okay, I'm sorry. On this, all the time you said something about after the end of the agreement that's between them, that the other party might not want to stop using the name, and as such, how can the other party, the owner of the product itself, the trademark itself, how can he get it right? Like what can he do to stop that action?
Okay, it's not a general rule, it's just an exception for the bad guys. Anybody so that's why I said that you need to look at the agreement as a lawyer. Look at every agreement that at the end of 10 years, this is what you give. Then you have arbitration clause if you need to go to court. So you put everything in order. That way, if they know that the law is against them and you put everything, but some people will come to Nigeria and tell you, oh, we want to do a franchise. They start doing business before the agreement. That's when they fall into trouble. But don't worry, the agreement is always there to straighten up things. So that's what you would do to protect your client from having somebody take their name and don't want to give it up. I hope that helps.
Yes, ma. Yes, ma. Thank you so much. It's very understood now, the way you explained it. So I think that we'll move to the next person that has their hand up. Stephen.
Hello, good evening. Just to be sure, can you hear me?
Yes.
Yes, we can hear you.
Can you hear me?
Yes, Stephen, we can hear you.
Okay. I had a super insightful section today, and I really want to say thank you for giving me the opportunity to be here. So first of all, I have two questions. The first is, can football skills be protected under intellectual property laws? Can football skills be protected? And the second one is, the second question is, can tailoring designs be protected under intellectual property laws? So those are my two questions. Thank you.
Can you please write this question on the chat?
The first time, did you say football field?
Football skills.
Football.
Yes.
Oh, okay, skills. Yeah, under copyright sometimes, because you have skills and then you put it down as your copyrights and all of that. The way the skill is different from any other person, it's never been done and all of that. Yes, you can. I know we've registered copyright for somebody that started, I can't remember exactly, but something like football and then betting and stuff like that. And then what was the other one? The other question?
Tailoring design, man. Tailoring design.
Oh, yes, of course. It's a design. If you listen to the person that gave a presentation on design, yeah, those design, architecture, designing your house in a particular way. Some architects, when they do the design for people, it's intellectual property. They keep their design where you see it. In fact, I know a law firm in South Africa that if you go to all their branches, both in Durban or Cape Town, is the same designs. Yes, you can, everything, intellectual property is in every business we do. It's the most valued asset we can own. Yeah, so there's IP in all of those.
Thank you so much, ma'am.
Okay, thank you very much, ma, also for responding. I don't know if Sandra is still with us.
Yes, I'm here, ma'am.
Okay. So if you have
There's
a
a
question,
last person, but I don't know.
Okay.
I saw one Kum raise his hand. It's a while ago.
Yeah, sorry, it's a she. And I think the
It's very
first guy
sorry.
already, the first guy asked my question. I had actually typed it in the chat box, but he asked my question. So it was responded to accurately. Thank you.
Okay.
All right.
Great. Do we have any other question? Do we have any other person that has a question? This is your time to ask your question while you still have the mentors with you.
I have a question. So someone has already the man that spoke, he has already talked about this, but I'm not quite clear. Someone asked that, okay, patent after its expiration, can it be renewed? So I did not get what was saying. I need clear explanation on that, man. So did you get my question?
There's an answer in the chat box.
On that.
Mr. Marx, after expiration, a patentee loses the monopoly / exclusive rights. So anyone can work with the patent without the liability for infringement. Remember that in return for the grant of patent, the patentee must disclose the full working. So I believe that answers your question.
Okay, so if we've taken all the questions. Sorry, Ma, please, do you want to respond to it, Ma?
No, I agree with Mr. Mark. I was just gonna tell the person that asked the question. I mean, you had 20 years to enjoy it. It's a long time, unless if you made some amendments, brought something new. Once it expires, it goes to public domain.
Okay, Ma. Thank you. So I can see that Mariam's hand is up. You can ask your question.
Okay, thank you very much. I already asked it in the comment section, but I'm not very clear on it if it was answered. It's concerning a trademark, that's registered outside Nigeria. My question is, if it hasn't been registered with the Corporate Affairs Commission here in Nigeria, can it be registered as a trademark? That's a university, for instance, that is already doing business outside Nigeria. Can it be registered as a trademark first before going on with the Corporate Affairs Commission registration?
So you're talking about the Nigerian registering as and vice versa, because intellectual property is territorial. So if you're a Nigerian and you're doing business, it's a university. If you want to use it overseas, you have to register as a company in overseas. And then nothing stops you from registering as a company and registering your trade name. But there are two different things. Whilst the name of the university is a trade name, there's an intellectual property in it, perhaps their logo, what they stand for. So you have to take trademark out of the company registry. It happens in Nigeria. Oftentimes people run and go and register because they know the registry will tell them that somebody has registered trademark, you can't register it. Then they run to CAC to go and register the trademark as a company name. But there's a law, the CAC, the CAMA provides that you cannot register a company if it contravenes with a trademark that is in existence in Nigeria at the time of you incorporating the company. So please know that it's territorial. Anything you did, like the first speaker rightly said, protection, registration is key. You have to register. And you need to look at each jurisdiction, his territory, to know what their registry require. Remember that we had said that registration in Nigeria is valid for the first 7 years before you renew, whereas in Madrid Protocol is 10 years. So you need to look at the law where you want to do business to make sure you do the right thing and not run counter of the country's law.
Okay, Ma, thank you very much. But just to ask further that, for instance, some of these international conventions that we have, let's take US, for instance, and this organization is already registered in US, and they want to extend their business to Nigeria. Do they necessarily have to start by registering with the CAC first, or can they, for the purpose of that protection, international protection, have their logo or trademark now registered?
I get your point. I get your point, but please, you have to know the distinction between company name and trademark. So you're talking about conventions that had to deal with trademark, and you said that in America, and they're in one convention like PCT, the Patent Cooperation Treaty. If they register, we have pharmaceutical companies that will register and lodge the application with WIPO in Switzerland, then they nominate Nigeria. Then we can, you see, they're taking action. They're not just coming to do business. They know that even though they've registered, they're claiming priority. They said, we've registered in WIPO. Now we want to do business in Nigeria, so we want to register in Nigeria. So until you do that, you'll be running against the company's law, the country's law. So whatever you want to do, you need to check, even online, check what is required in that jurisdiction. Then if you follow the law, you won't go wrong. But please know that corporate affairs or company secretaries had to do with name, trade name, like Coca-Cola company. The Coca-Cola company is called TCC. Is the trade name. It happened that they have a trademark that is the same with their trade name, but they have other trademarks like Fanta, Sprite. So please always distinguish between trade name and trademark. They are two different things.
Okay, well noted, Ma. Thank you very much.
All right.
Okay. Thank you so much, ma'am. I don't know if there are other questions. Miriam, your hand. Your hand.
Oh no, I don't have any other question.
Oh, okay. Okay. Thank you so much to everyone.
Audio now unmuted.
Thank you
Yeah.
to
Yeah, this is Gabriel.
thank you to the mentors. And the mentees. Thank you, Mrs. Juliana. I'll be handing over to Mrs. Juliana.
Thank you so much, Sandra, for moderating the session today. Sorry, my network was off, but I just came in now. So thank you so much for moderating the session today. We are so grateful that you volunteered to moderate the session. Thank you, Nirvana, for joining us today. Thank you for sharing from your wealth of experience. Sorry, it's about to rain here. Thank you so much, Mrs. Uche. You have been a source of strength to us throughout all these years. And we want to say a very big thank you to you, Ma. Thank you, Mr. Max, also for, thank you, Mr. Max, also for being with us. And want to say thank you to all the mentors, all the mentees, everyone who has worked with us so far. Thank you so much. So we've come to the end of the session today and would like to wish everyone an amazing weekend. Sorry for the background. Sorry for the background noise. They just took light and my children just ran in.
No problem.
Thank you, everyone. Thank you, everyone. Please have an amazing weekend.
Nice to meet you. Nice to meet you all.
Thank you. Thank you so much.
Thank you
so much,
Nirvana.
ma'am.
Nice to meet you, ma'am.
Thank you.
Bye.
Mrs.
Nirvana, it
Uche.
was nice to have you. Thank you, guys.
Bye-bye.
Bye. Thank
Thank
you.
you, everyone.
Bye. Good night.